A federal judge now ordering the Trump administration to pay out all SNAP benefits, what used to be called food stamps. They're saying you got to pay out all those benefits for the month of November by tomorrow. Not just the partial distribution the Trump administration already said they would do, with a lot of people right now still in the dark on when they're actually going to get those benefits. What does it mean for the 42 million people who rely on the country's biggest food assistance program? Honestly, TBD at this point, at least on some of the details. The White House is directing our team to the Office of Management and Budget. We haven't heard back from them yet for a comment. We're going to be watching that over the course of the next hour. But the move from the judge comes as pressure is cranking up on Congress to end what is now the longest government shutdown in American history. Right now, we are just hours away from seeing a cutback in flights at 40 big airports across the country: New York, Chicago, Atlanta, and more. United's already canceling nearly 200 flights tomorrow, Delta 170. And this is just the beginning, because these cuts could escalate to something like 4,000 flights daily sometime next week, meaning things may get a whole lot worse for a lot more travelers.
Hi, guys. Adam is here. So what just happened, the financial and legal net closing around Trump is unlike anything ever assembled against a sitting American president. And the sheer weight of it is producing a public meltdown unlike anything we've seen from him before. We've watched him stand at podiums, microphones in his face, calling judges crooked, calling prosecutors corrupt, calling findings of fraud a disgrace, and a fine for doing a perfect job.
Deranged Jack Smith, in my opinion, is a criminal. And I noticed his interviewer was, I think that was Weissman. And I hope they're going to look into Weissman, too. Weissman's a bad guy. And he had somebody in, Lisa, who was his puppet, worked in the office really as the top person. And I think that she should be looked at very strongly. I hope they're looking at Shifty Schiff. I hope they're looking at all these people. And I'm allowed to find out. I'm allowed to, I'm, in theory, the chief law enforcement officer.
But here's the thing about that performance. It's not just bluster. It's the documented behavioral signature of someone watching courts systematically strip away the financial foundation he spent decades building, one ruling at a time, across multiple jurisdictions, in personal cases, business cases, even international cases.
Let me just read a little bit from the summary from Judge Engoron's decision, because I think it's worth just reading out loud. In order to borrow more and at lower rates, defendants submitted blatantly false financial data to the accountants, resulting in fraudulent financial statements. When confronted at trial with the statements, defendants' fact and expert witnesses simply denied reality. And defendants failed to accept responsibility or to impose internal controls to prevent future recurrences. As detailed herein, this court now finds defendants liable, continues the appointment of an independent monitor, orders the installation of an independent director of compliance, and limits defendants' right to conduct business in New York for a few years.
The numbers are staggering. We're talking about $500 million in confirmed financial obligations, civil fraud judgments, defamation damages, international legal fees. And then on top of all that, federal courts ordering his own administration to refund billions in unlawful tariffs, establishing that the payback millions pattern extends from his personal business empire all the way into the machinery of government itself. And his response to each of these orders? The same pattern every single time. Attack the judge, attack the prosecutor, claim political persecution, call the findings a joke, but the courts aren't laughing. The appeals courts are confirming these obligations. The interest is accruing daily, and the enforcement machinery is moving closer with every passing day. Let me take you inside exactly what's happening, because the story behind the headlines is far more devastating to the defense position than any single courtroom moment could ever capture. Let's start with the biggest single financial hammer in this entire story. Judge Arthur Engoron, after extensive evidentiary proceedings in New York, found that Trump, his adult sons, and the Trump Organization committed what the Attorney General called staggering fraud. Not a small mistake. Not an accounting error. Persistent, systematic fraud carried out over multiple years. Here's what the evidence showed. The Trump Organization was submitting financial statements to banks like Deutsche Bank and Ladder Capital, to insurance companies, to financial institutions, with property values inflated so dramatically that in some cases the numbers were multiples of what independent appraisals would have produced. Mar-a-Lago was valued as if it could be developed for residential use, despite deed restrictions specifically prohibiting that use. Seven Springs was valued based on development rights that had never been obtained. Trump Tower valuations overstated residential unit values in ways that couldn't be justified by any legitimate accounting method. This wasn't one transaction. It wasn't an isolated incident. It was a pattern, a scheme, a persistent practice of submitting fraudulent numbers across multiple properties, multiple financial statements, multiple submission cycles, all designed to secure better loan terms and more favorable insurance rates than accurate valuations would have supported. Judge Engoron looked at this evidence and made a specific finding: persistent fraud. And then he did something that goes to the very heart of what this case is really about. He didn't just impose a punitive fine. He ordered disgorgement, more than $355 million in disgorgement, growing to over $450 million with interest, plus a 3-year ban on Trump serving as an officer or director of any New York company. Now, you need to understand why the word disgorgement matters so much. A fine is a punishment. It's the court saying, you did something wrong and we're going to make you pay for it. Disgorgement is something fundamentally different. Disgorgement is the legal mechanism for stripping away the specific financial benefits that wrongful conduct produced and returning those benefits to the state and to the victims of the fraud. It's not punishment, it's restoration. It's the court saying, you got this money through fraud, so you have to give it back. New York Attorney General Letitia James put it in even starker terms. She called the conduct lying, cheating, and staggering fraud, and she described the judgment as forcing Trump to return money he fraudulently and illegally obtained. That framing is devastating because it directly refutes the narrative Trump has been pushing. He calls it a fine for doing a perfect job, but disgorgement isn't a fine for how you did business. It's a requirement to give back what you stole by doing business that way. But the civil fraud judgment is just the beginning of this financial accountability story. While that case was working its way through the courts, a separate legal saga was unfolding that would add another massive layer to the stack of financial obligations. The E. Jean Carroll defamation cases, 2 trials, 2 juries, and approximately $88 million in damages. Here's how it played out. The first trial established the underlying liability and produced an initial damage award. The second trial addressed the additional defamation damages that came from Trump's public statements after the first verdict. Statements where he continued to call Carroll a liar, continued to claim she was making false accusations, continued to defame her even after a jury had already found against him. The 2 trials together produced a total damage award of approximately $88 million. And here's the critical development that most people missed. The appeals court confirmed those verdicts and those damages. That confirmation is huge. A trial court judgment, no matter how substantial, is always subject to the possibility of appellate reversal, the chance that a higher court could eliminate or significantly reduce the obligation. But when an appellate court confirms the verdict and the damages, that possibility gets foreclosed. The $88 million stops being a pending obligation subject to reversal and becomes a confirmed financial liability that enforcement proceedings can rely on as a stable target. The Carroll damages are different in character from the civil fraud disgorgement. The fraud judgment is about returning stolen financial gains. The Carroll damages are about compensating for specific documented harm. The damage to Carroll's reputation, the emotional harm caused by the defamatory statements. But different character or not, they stack. And when you stack $450 million from the fraud case with $88 million from the Carroll cases, you're looking at more than $500 million in confirmed financial obligations from 2 separate proceedings. But the story doesn't stop there. While all of this was happening in American courts, a London court added an international dimension to the financial accountability picture. A judge in the United Kingdom ordered Trump to pay approximately $626,000, roughly $821,000, in legal fees to a firm called Orbit Business Intelligence. That's the firm linked to Christopher Steele, the former British spy whose dossier played such a prominent role in the early Russia investigation narrative. an international legal fee order extending the payback millions accountability across the Atlantic. And then there's the governmental dimension. Federal courts have issued multiple rulings ordering the Trump administration to refund billions in unlawful tariffs and to release hundreds of millions in unlawfully frozen grant funds. The Supreme Court itself weighed in on the tariff issue, ruling that the administration had overstepped its authority in imposing certain tariff regimes. The result? Billions of dollars that had been collected unlawfully now have to be refunded. Billions that had been frozen unlawfully now have to be released. This is the piece that most people don't fully appreciate. The accountability isn't just personal, it isn't just business. It extends to the governmental conduct of the administration itself. Courts are telling Trump world to give money back across every domain simultaneously: personal fraud, defamation damages, international legal fees, unlawful tariffs, frozen grants. The pattern is unmistakable. The numbers are staggering, and the cumulative weight is producing a response that's equally unmistakable. Now let's talk about that response, because Trump's documented reaction to these financial orders is some of the most revealing evidence we have about what's actually happening behind the public narrative. We've watched him stand in front of cameras and call Judge Engoron crooked. We've heard him call Letitia James corrupt. We've seen him tell reporters that the civil fraud decision was a disgrace and that the $355 million was a fine for doing a perfect job. We've watched him attack the Carroll verdicts with the same language, the same fury, the same refusal to engage with the actual legal findings. But here's the thing. Calling a fraud disgorgement order a fine for doing a perfect job isn't just inaccurate. It's revealing. It tells you that the person saying it either genuinely cannot understand the distinction between legitimate business and documented fraud, or he's performing that inability for the political audience whose support depends on accepting the performance at face value. A defendant who believes their position is legally sound doesn't need to attack the judges. They let the appeals process work. They let the legal arguments speak for themselves. A defendant who understands that the legal position is losing, that the fraud findings have been confirmed, that the damages have been upheld, that the escape routes are closing, attacks the judges because attacking the messenger becomes the only alternative to engaging with the message. The losing it is real. It's documented. It's escalating. And it's directly proportional to the size and scope of the financial obligations being stacked against him. Let me give you 4 clear points that capture exactly what's happening and why it matters so much. First, the disgorgement framing of the civil fraud judgment is the single most legally and politically significant dimension of the entire financial accountability story. When the Attorney General describes the $450 million order as forcing Trump to return money he fraudulently obtained, she's not just making a political statement. She's invoking a specific legal mechanism with a specific legal meaning. Disgorgement isn't punishment, it's restoration. It's the court's way of saying, you got these financial benefits through fraud, so you have to give them back. Trump's characterization of the same order as a fine for doing a perfect job is the most specific available documentation of the losing it dynamic. Because you can't claim you're being arbitrarily punished when the court is literally requiring you to return the specific money that its findings say you obtained through fraud. Second, the Carroll Appeals Court confirmation is the most significant legal development in the defamation dimension of this story. Trial court judgments are always vulnerable to appellate reversal. An appellate court that confirms both the verdict and the damages closes that escape route entirely. The $88 million stops being a contested number and becomes a confirmed liability. When you add that confirmed liability to the $450 million from the fraud case, you're looking at a stack approaching $600 million in confirmed financial obligations. That's the number that's driving the bond situation, the liquidity pressure, and the escalating behavioral response. Third, the combination of personal, business, international, and governmental financial accountability creates the most comprehensive picture ever assembled against any sitting or former American president. Trump's public narrative has always maintained a distinction between his personal business conduct, characterized as a perfect job, and his governmental conduct, characterized as the most successful presidency in history. The stacked accountability picture demolishes both dimensions simultaneously. The civil fraud disgorgement demolishes the perfect job narrative. The tariff refund orders and grant rulings demolish the most successful presidency narrative. Courts are telling Trump world to give money back across every domain simultaneously, and that comprehensive character is what makes the losing it response so acute. Fourth, here's what we need to watch as this story continues to develop. The civil fraud appellate resolution will determine the final dollar amount that anchors the entire enforcement trajectory. And every day of appellate delay adds approximately $87,500 in interest to the total obligation. The Carroll enforcement proceedings will test whether James Carroll's attorneys pursue the specific account search and levy mechanisms that the confirmed appellate judgment makes available. The James seizure commitment, naming properties and committing on camera to pursue the most aggressive available enforcement, will be tested by the bond situation and appellate timeline that determine when the enforcement window actually opens, and the tariff refund proceedings will determine whether the billions in unlawful tariffs ordered refunded are actually processed through the administrative mechanisms the rulings require. Here's the bottom line on everything we've covered. Judge Engoron found that Trump and the Trump Organization committed persistent fraud by systematically inflating property values in financial statements submitted to banks and insurance companies. He ordered more than $355 million in disgorgement, growing to over $450 million with interest, and banned Trump from serving as an officer or director of any New York company for 3 years. Attorney General James called the conduct lying, cheating, and staggering fraud, describing the judgment as forcing Trump to return money he fraudulently and illegally obtained. The E. Jean Carroll defamation trials produced approximately $88 million in confirmed damages, upheld by the appeals court, adding the defamation accountability to the civil fraud disgorgement in ways that stack the confirmed financial obligations toward $600 million. A London court ordered approximately $821,000 in legal fees to Orbit Business Intelligence, extending the payback millions accountability across international jurisdictions. Federal courts ordered billions in unlawful tariff refunds and blocked hundreds of millions in unlawfully frozen grants, establishing that the payback millions pattern extends from Trump's personal and business conduct to the governmental conduct of his administration. Trump told reporters the civil fraud decision was a disgrace, a fine for doing a perfect job. He attacked Engoron as crooked and James as corrupt. Those statements are the most publicly documented available behavioral expression of the losing it dynamic that the most comprehensive financial accountability picture ever assembled against a sitting or former American president is producing. The judge ordered him to pay back millions. The appeals courts confirmed the orders. The enforcement machinery is moving, and the daily accrual, approximately $87,500 per day on the fraud judgment alone, is ensuring that every day of delay makes the eventual payback more financially catastrophic rather than less. Stay tuned. The appellate proceedings are active. The enforcement window is approaching, and we're going to be right here covering every single development as it unfolds. If you're not subscribed yet, hit that button right now. Drop a comment below and tell me what you think. Does the stack financial accountability produce the voluntary payment that satisfies the judgments before the enforcement machinery reaches the seizure stage? Or does the losing it response continue as the courts escalate toward the most aggressive available financial accountability? I want to hear from you.